Good day, everyone, and greetings from San Francisco, California. My name is Dr. Matthew Kemner, and I'm a partner at Squire, Patton, Boggs here in the San Francisco office. I'm a partner of Bindu, who will be giving her presentation a bit later and leading our panel discussion group. We are an international law firm with 45 offices and over 1,500 lawyers worldwide. And we need this platform to serve our clients who are serving the economy on a global basis. I want to very much say what an honor it is to be able to speak at this, the 10th annual Business Law Congress, and really have looked forward to speaking at the GENNEXT Business and Law Congress, and it's great to be here. Because of COVID, I can't join you. I can't join you live, but I can at least join you virtually. And you'll hear me now on video, and then a little bit later, because it's 3 in the morning, my time as you're listening to this, I'll be joining you for the question and answer period, and that will be live. I was asked to talk about the spread of U.S.-style litigation and the risks of U.S.-style civil litigation spreading, particularly in strict liability claims, and also in class action or collective redress claims. And this is exactly what we do. And it wasn't hard really to think about an analogy. Really, I think, and I say this in a self-critical way because I'm an American, but I think that US-style litigation, I would almost analogize it to a virus. It's a virus that started here in the US and it's unfortunately spreading. That's the bad news. It's a little bit like you look at COVID. COVID started in one place in the world and eventually it was involved, it overtook the whole world, and we're all dealing with this challenge. That happened quickly. I think US-style litigation is obviously spreading a bit slower, but not much. I think we're going to find out that US-style litigation is causing companies outside the US to be concerned in Europe, in South America, and in Asia. This is something that it's not really a question of whether it's going to continue to spread. It's not a question of whether the trend is to be more like, unfortunately, US law in that regard. The question is when. We think the answer, and our clients agree, is that coordination is the answer. Here at Squire, we have set up a coordination program, a worldwide civil litigation coordination program for various clients of ours, both in the United States as well as in Europe. And it's been tremendously successful to keep make sure that our clients are able to defend themselves and not fall prey to this litigation virus, as I said. When I say coordination, what I mean is we have a team of lawyers that monitors legal developments worldwide. And then for our clients, wherever our clients do business, we make sure that, let's just say it's a product. We do some work for German automobile manufacturers. Let's just say it's the same car, the same model car, but one of them happens to have a claim of a defect in India, whereas the other one, same car, has a similar defect claim in Indiana, in the United States. Well, it doesn't matter. For us, we're focused on making sure that our defense in India is the same as our defense in the United States, fully consistent. That coordination is that level of lawyers that can assist a company that's doing business outside of its own borders, as I think most of the clients that are participating in today's conference probably are doing. That's probably why you're here. We don't have to look too far to see how the virus has spread, so to say. Now, you know about US-style product liability cases. Back in the 50s, we went from a standard of a manufacturer having to be negligent or having to do intentional wrong to a standard of strict liability. In other words, if there's anything wrong with the product, whether the manufacturer was at fault or wasn't at fault, we're going to find him liable. Not long after that, we also shifted to a civil litigation system that allowed for class actions. Now, class action is obviously civil litigation where one plaintiff can file a lawsuit attempting to represent non-parties, but other people, non-parties to the claim, that are similar in some way, that have similar questions of law or fact. Now, this mechanism, this United States mechanism, has spread throughout the world, and we don't have to look too far. If we stay here in the Americas, we can see that in Argentina in 1994, they put their foot in the water, so to say, and they started adopting, through their civil code, a collective redress class action system. In Mexico, they adopted into the civil code in 2011, just 7 years later. And of course, you know about Canada. Canada is probably it's not only the closest to America geographically, but it's also the closest to America in its adoption of class actions, because we have large-scale class actions, and they've also adopted discovery, where, in other words, in many jurisdictions, you can't sue someone and say, give me all your documents. This is what we call discovery in the U.S., but you can in the U.S. You sue someone and you use that company's documents against you. Unfortunately, this style of discovery has spread to Canada. So we have it in Mexico, U.S., and Canada. It doesn't stop in the Americas, though. If we look over in Europe, I would say, usually from the civil litigation side, a fairly conservative geography, but they've adopted as well. The Netherlands adopted an opt-out system. Now remember the difference between an opt-in system and an opt-out system. When someone files a class action, presumably in the United States, you are a member, you get notice, but you're a member of that class until after you get notice you decide to opt out. So in other words, you tell the court, look, I know everyone else is in that class action, I'm going to opt out. Many places still only have an opt-in system, which is much more favorable to a defendant. An individual is not a member of a class until they try to opt in. They say, okay, I'd like to be a member. Just the opposite for opt out. Opt out, much more dangerous. Germany, where we do a tremendous amount of work, they adopted in 2018 the Musterfeststellungsklage as part of the Zivilgesetz. That was 2018, 3 years ago, and now they're evolving toward more opportunities, closer, of course not yet the U.S. system, but they're migrating in that direction. And then, of course, it doesn't stop at Europe either. If we can look at Asia, from one side of Asia to the other, there are certain, all the trends are just what we predicted and just what we see to keep evolving in that direction. It's going to be more toward being pro-plaintiff, pro-class action, and pro-strict liability on these types of product claims. Take, for example, Korea. Korea allows collective action in a form of class actions already. Japan, Indonesia, Thailand, all these countries have sort of adopted that approach in one form or another. And then I don't need to tell this audience, of course, India in the Companies Act of 2013 took a step toward that direction. You know, this is first shareholder actions, but it's going to, we think it's going to keep evolving. That's sort of the bad news. The good news is there's a robust world economy out there, and there's a way to do business on a worldwide basis, but manage your risk. And as I said before, that's with coordination and what we offer our clients. So what we try to do when we say coordination is be that law firm that is shoulder to shoulder with the client and help them navigate their worldwide business. So we know that whether, it doesn't really matter to that client whether, let's just take a German automobile, whether that German automobile has a problem in Beijing, China, or in Buenos Aires, Argentina. If it's the same problem, we've got to be consistent. Through coordination, we can learn the best defense to certain attacks on defect theories. We can learn to avoid mistakes. We can ensure consistency. And in the end, we can save money. Because if you look at the last 20 years, both on the, for example, in the financial services sector, product manufacturing sector, civil litigation not defended properly has resulted in huge losses in civil litigation to the clients. What we're here to do is get in front of that. What our clients like our approach, this coordination approach, is because we can reduce the risk tremendously that something like that can lead to unacceptable losses. Now, we are U.S. lawyers and we operate outside the U.S. We always have a local counsel. So for instance, although I am an American, I spent part of my legal education in Germany. Our team is international by nature. Bindu will, living in Singapore now, she'll let you know her background as well. But we have offices, 2 offices in China. We have offices throughout Europe. And the UK, I guess I have to say the UK as well, which is sort of in Europe now and sort of out of Europe. And then we can't have offices, as you know, in India based on legal restrictions, but we do have special relationships with law firms there that we can team up. Because we have clients in India. We have European clients and American clients who do business in India, and we can help them. We can help them mitigate their risk. Anyway, I'm very excited to be here today. I'll be talking a little bit later to you live, I think, and that'll be in the question and answer period, which won't be at 3 in the morning my time. It'll be just a bit later. But I'll be able to answer any questions you have. If I can leave you with one thought, we don't really think of our team that we offer these clients on an international basis just a litigation team. What we're really offering is risk management. What we're offering is product risk reduction, services litigation risk reduction. Through our coordination system, we think we can do that. We can help you avoid the big risk and help your company succeed better. So with that, I will turn it back to Bindu, and thank you all again for having me, and I look forward to seeing you or at least talking to you live in a few hours at the question and answer period. Thank you very much.